For a long time, federal gun law has carried an air of finality. Certain rules were treated as settled, not because they were continually re-examined, but because they faded into the background of legal life. They became part of the furniture, rarely questioned, rarely revisited. Lately, however, something has shifted. In quiet judicial opinions rather than public debate, federal judges have begun pulling on a loose constitutional thread. What they are uncovering is not a disagreement over policy, but a fundamental question about whether Congress stayed within its constitutional lane when it drew one of the most significant lines in modern firearms law. The statute drawing renewed attention is 18 U.S.C., paragraph 922, the provision tied to the long-standing restriction on civilian possession of machine guns manufactured after May 19, 1986. That single date functions as a hard boundary in federal law. Firearms made before it may still be lawfully owned by civilians, but only through the demanding framework of the National Firearms Act. That process includes registration, fingerprinting, extensive background checks, and the payment of a federal tax. Firearms manufactured after the cutoff are treated entirely differently. They are barred from civilian possession altogether, regardless of an individual's background, compliance history, or willingness to submit to regulation. This legal structure has been in place for nearly 4 decades. During that time, it was enforced consistently and upheld repeatedly. Challenges arose, but they were usually resolved by pointing to precedent rather than by examining whether the statute itself rested on solid constitutional ground. That pattern has started to break. Judges are now asking a question that has lingered quietly since the law's passage. What constitutional power exactly allowed Congress to enact this ban? Answering that question requires stepping back to first principles. The federal government does not possess general authority to legislate on any subject it chooses. Under the Constitution, it operates under a system of enumerated powers. Article Y lists the specific areas where Congress may act, including the power to tax, to regulate interstate commerce, and to enact laws necessary and proper to carry out those functions. Powers not granted to the federal government are reserved to the states or to the people. This framework is more than theory. It is a structural safeguard. When Congress creates a federal crime, it must be able to tie that law to one of its enumerated powers. Without that connection, the law risks transforming the federal government into a general police authority, something the Constitution deliberately avoided. The renewed judicial scrutiny of paragraph 922 centers on whether the post-1986 machine gun restriction satisfies this basic requirement. Historically, federal firearms regulation has leaned on 2 main constitutional foundations: taxation and interstate commerce. The National Firearms Act is the clearest example of the first. Congress imposed taxes and registration requirements on certain weapons, and lawful possession was conditioned on compliance. Whether one supports or opposes that approach, its constitutional basis was explicit. Congress was exercising its power to tax and administer revenue-related regulation. The post-1986 machine gun ban does not follow that model. There is no registration pathway for newly manufactured machine guns. There is no tax that can be paid, no form that can be submitted, and no regulatory process that can be completed to make possession lawful. The Bureau of Alcohol, Tobacco, Firearms, and Explosives will not accept an application or a tax payment under any circumstances. As a result, the taxing power cannot realistically serve as the statute's constitutional foundation. There is no tax, no revenue stream, and no fiscal regulation involved. That leaves the Commerce Clause as the remaining possible source of authority. The Commerce Clause allows Congress to regulate interstate commerce and, under modern case law, certain activities that substantially affect it. Many federal gun statutes include explicit language tying the prohibited conduct to interstate commerce, such as requiring proof that a firearm traveled across state lines or was sold through commercial channels. That language serves as a jurisdictional anchor, connecting the statute to Congress's constitutional power. The machine gun provision in paragraph 922 contains no such anchor. It criminalizes possession itself without requiring any showing that the firearm moved across state lines, was sold commercially, or affected interstate markets in any way. Prosecutors are not required to prove a commercial connection as part of the offense. This is not an accidental gap or an implied assumption. It is a feature of the statute as written. That silence is now the focus of constitutional concern. This issue was identified years ago, though it received little attention at the time. In the late 1990s, then Judge Samuel Alito raised the concern in a dissent while serving on the U.S. Court of Appeals. In United States v. Rybar, he questioned whether Congress had grounded the machine gun ban in any enumerated power at all. He observed that the statute was neither tied to taxation nor to interstate commerce, and warned that this omission placed the law on uncertain constitutional footing. His dissent did not alter the outcome of the case, and the statute remained in force. For many years, that warning lay dormant. Courts continue to uphold the ban, largely by relying on precedent rather than revisiting its structural foundation. But legal arguments do not disappear simply because they are ignored. They remain available, waiting for a moment when courts are prepared to return to first principles. That moment appears to be arriving. A recent case in the Fifth Circuit brought renewed attention to the issue. The case involved a defendant charged with serious violent offenses, including crimes involving a firearm converted into a machine gun. In addition to the primary charges, prosecutors included a separate count under paragraph 922 for possession of a post-1986 machine gun. The defense challenged that count, arguing that the statute itself exceeded Congress's constitutional authority. The appellate court ultimately upheld the conviction, but the reasoning behind the decision is what matters. The judges explained that they were bound by existing circuit precedent under a doctrine known as the rule of orderliness. Under that rule, appellate panels must follow prior decisions of the same circuit, unless those decisions are overturned by the full court or the Supreme Court. In this case, earlier precedent had upheld the statute, leaving the panel no room to rule otherwise. What made the decision significant was not the result, but the accompanying opinions. Several judges wrote separately to express serious reservations about the statute's constitutional basis. They emphasized that while precedent constrained their ruling, it did not resolve the underlying question of congressional authority. In their view, that question remains open and increasingly difficult to avoid. Judge Don Willett, a jurist with experience on both the Texas Supreme Court and the federal bench, articulated this concern with unusual clarity. He focused not on the Second Amendment, but on the Constitution's structure. In his analysis, every federal statute must rest on one or more of Congress's enumerated powers. The machine gun provision of paragraph 922, he argued, appears to rest on neither taxation nor interstate commerce. Without a valid constitutional hook, the law risks exceeding the limits of federal authority. Judge Willett A.S. reasoning drew heavily on Supreme Court cases that have constrained the reach of the Commerce Clause. He noted that simply possessing an item within a single state does not automatically fall within Congress' OS regulatory power. The nature of the item, even one as heavily regulated as a machine gun, does not by itself create federal jurisdiction. Possession alone, without a commercial or interstate connection, fits uneasily within established Commerce Clause categories. Another Fifth Circuit judge, James Ho, echoed these concerns in his own concurrence. He emphasized the federalism implications of allowing Congress to criminalize conduct without identifying a constitutional source of authority. In his view, courts have a responsibility to enforce the structural limits of the Constitution, even when doing so involves controversial subjects. Ignoring those limits, he suggested, undermines the separation of powers that protects individual liberty. The importance of these opinions lies in what they signal rather than what they immediately accomplish. The law remains in force. No precedent has been overturned. But when multiple judges, constrained by existing rulings, nonetheless take the time to highlight a statute's potential constitutional defects, it suggests that the issue is ripening for further review. Major legal shifts often begin this way, through careful questioning rather than sweeping declarations. It is also crucial to understand what this debate is not about. The judges raising these concerns are not minimizing the seriousness of violent crime, nor are they endorsing any particular policy outcome. Their focus is procedural and structural, not ideological. The Constitution requires Congress to operate within defined boundaries. Even widely supported goals must be pursued through constitutionally authorized means. When a law exceeds those bounds, courts are obligated to acknowledge it. This framing changes the conversation. The issue is not whether machine guns should be regulated. It is whether the specific mechanism Congress chose in 1986 aligns with the constitutional framework. Congress retains the ability to legislate within its enumerated powers. If it failed to do so here, the solution lies in legislative action, not judicial creativity. As this line of reasoning gains attention, it may eventually reach the Supreme Court. If that happens, the court would not be confronting a novel theory. It would be revisiting an argument that has been articulated, refined, and supported by members of the federal judiciary over decades. The fact that a concern raised long ago is resurfacing now highlights the enduring role of constitutional structure in American law. For the moment, paragraph 922 continues to be enforced as written. Existing precedent governs its application, and no immediate change has occurred. What has changed is the level of scrutiny being applied to the statute's foundations. Courts are increasingly willing to ask whether long-standing enforcement has taken the place of constitutional justification, and whether that substitution is consistent with a system of limited federal power. Legal systems evolve through moments like this. Sometimes laws are reaffirmed, sometimes they are revised, and sometimes they are set aside. Whatever the outcome, the current debate illustrates that constitutional interpretation is not frozen in time. It is an ongoing process of measuring statutes against the framework that gives them legitimacy. When judges return to first principles, they remind us that longevity alone does not guarantee validity, and that even the most familiar laws must ultimately answer to the Constitution itself.